Thank you so much, Patricia. And this is Cecelia Levin. I am Senior Policy Counsel with ASISTA. And Gail, unfortunately, is under the weather and can't be with us today. But I hope to be able to kind of guide you through what happens sometimes if you have that magical moment where you may have a victim that is potentially eligible for more than one type of immigration benefit. And so we're going to talk a little bit about how to navigate those arenas. We're going to talk a little bit about some most common immigration statuses for survivors, talk about some pros and cons and how some of the different requirements of the eligibility might affect what you're going to file, and then talk about ways that you can help your clients kind of document what they need to submit these applications. And if I could just, by raising of your virtual hands, I think that there's a button on the upper right, left-hand side of the Adobe Connect. If I can get a sense of how many people have already helped survivors file a form of immigration relief, if that's a VAWA self-petition, a U visa, T visa, if you can just raise your virtual hands. Cassie, Catherine, Raquel, EC, Wendy, okay, great. Daisy, all right, so we already have some kind of, Karen, awesome. So we already have some experts in the room, and I definitely invite you to write in the chat box if you've had a particular experience or something that you've done that you think is a best practice, because even though we're not in the same room as one another, we can take this as an opportunity to learn from each other, learn what works, what difficulties or challenges you've had. And so in as much as possible in this format, we'll try to kind of share our experiences working on these cases. All right, so why don't we go ahead and get started. So there are a few options that are available to survivors of domestic violence, sexual assault, human trafficking. And a lot of this depends on a myriad of factors. For example, where the abuse occurred, how long ago, who the abuser was, the immigration status of the abuser. And so there are different factors that are at play. And so not to give that typical lawyer answer, but what options are available really depend, right? And so we're going to talk a little bit about a few of these today. We have forms of relief that were created as part of the Violence Against Women Act, and including those, the Violence Against Women Act of 1994 created the VAWA self-petition. But even before VAWA was enacted, there was protection for conditional residents who were victims of domestic violence. So we're going to talk about what they call battered spouse waivers, or I call them domestic violence waivers, in the context of conditional residency. We're going to talk about U visas, T visas, go over basic elements of gender-based asylum, and also special immigrant juvenile status. And so the goal of the webinar today is not necessarily to have you be complete experts in identifying these cases or knowing the ins and outs in terms of the requirements or what might cause be some red flags. But just to kind of get you thinking and issue spotting and kind of seeing, okay, these are the facts that might push a case in one direction and the other. And of course, as OVW grantees, you have access to our technical assistance anytime that you need it. If you're trying to figure out potential forms of immigration relief or go through kind of the stickier issues in your case, we are available to help. So why don't we go ahead and get started. And so how many folks are domestic violence or sexual assault survivor advocates? Can I also have you raise your virtual hands again? All right, so Peter, Norma, Raquel, Karen, all right, Sandra, great. And so I think that these are some things that we have identified in terms of the advocate's role in helping survivor with a case related to their immigration benefits. And I think a lot of it is just a knowledge of the system. If we're thinking about kind of forms of immigration-related abuse, and a lot of that is isolation from the abusers, and also kind of misinformation about what will happen if services are accessed. If you call the police and they're going to find out that you're undocumented and you are going to be deported and separated from your kids. And so I think that a lot of the important work that we do is explaining the system, explaining what it means if once they walk into your door, what confidentiality means, whether or not you have any kind of relationship with a government entity, whether or not you're going to pass their information on to immigration enforcement or to any other kind of, to the police. So having a sense of, and I think that the Minnesota Coalition for Battered Women on their website have really wonderful kind of outreach documents. I think it's in 12 different languages that kind of say that their services are available for everyone who is a victim, if they are undocumented, if they are a refugee, if they're an immigrant. And so I think getting a sense of kind of that your agency is one in which all have access to. And again, kind of remembering that the obligations that you do have under OVW, under FIPSA, in terms of the non-discrimination policies that we have to follow, in terms of not discriminating against individuals on the basis of their national origin. And so making sure that people know that your services are available regardless of immigration status, how the information they share once they walk through your doors, how that's going to be treated, what their rights are in their system. For example, everyone has the right to report a crime. Everyone, regardless of immigration status, has the right to get a protection order or to file some kind of case in family court. And so I think it's really important to kind of make sure that we are sharing that kind of information in terms of making sure that people understand and have a knowledge of their rights. Because again, part of what we consider to be immigration-related abuse is the manipulation and isolation from those outside resources. So I think kind of making sure that the information you're providing in terms of access, in terms of, oh my goodness, is there some kind of, and doing kind of some immigration-relating safety planning. How many people are incorporating immigration issues to their safety plans with survivors? Again, raise your virtual hands. Catherine, Sandra, Daisy. Okay, great. This is good because in the same way where we were kind of talking about the risks, safety planning in the context of domestic violence or sexual assault is often kind of thought about kind of what to do to avoid or prevent risks or harm from an abuser, right? And so I think that to meet the concerns of immigrant victims, and when I say immigrant victims, I want you to know that I'm not just talking about individuals who are undocumented. I can be also talking about individuals who are documented or who perhaps depend upon the abuser for their immigration status. And so I think similar to the way that safety planning is conducted in the event there's an encounter with an abuser, advocates can help victims think through what steps should be taken if the victim is arrested or detained by immigration enforcement. For example, advocates can help people identify who can take temporary care of their children. They can provide information, make sure that victims or survivors have the attorney or your advocate's business card in the event of emergencies. And also to make sure that your own staff is informed of what to do in the event, you know, the kind of what protocols and confidentiality protocols that you have as well in terms of doing some conversations around confidentiality within your own agency. And so some really great materials for that immigration safety planning are put forth by Clinic, the Catholic Legal Immigration Service. It has really good materials, as well as the Immigrant Legal Resource Center. That's ILRC. And they have some family planning documentation that you can talk to in terms of troubleshooting or talking about these issues and if there is a risk of being arrested or detained by ICE. And now when we're talking about the application for the immigration benefit itself, connecting providers with knowledgeable attorneys or accredited representatives who are knowledgeable in these forms of victim-based relief is really, really important. And also to help them corroborate the violence that they have suffered. If they have been to your shelter, to write a letter in support of their application saying that this is a person who accessed our services. Help identify and collect supporting documentation for a case. And for those of you who are advocates who have worked with immigrant survivors, is there anything else that you've done in terms of safety planning or helping someone apply for immigration benefits? Again, feel free to kind of just put this in the chat box, but if there's anything that you think in terms of that you have done that you think is an important part of your work with immigrant survivors, these are just some of the things that we've identified, but I think that they play an extremely important role. And I think, one, explaining how our systems work, explaining, and that could be, for example, I was speaking with recently an advocate who works on the border state, and they said that to go to get a SANE exam, they have to pass through an immigration checkpoint. And so are you coordinating with law enforcement in terms of how to have access to, how survivors can access the services that they need? So I think, okay, great. So Tatiana suggests get a contact for someone in their home country so that they can kind of keep in touch with them if the event of something happens. So I think, figuring out what safe cooperation with law enforcement looks like if they are afraid. And again, kind of the confidentiality in the terms of the context of your relationship. So just kind of knowing your rights, talking about how there are certain services that are available to survivors regardless of immigration status. And there is a joint letter from last year from DOJ, HHS, and also HUD. And I'm going to put that in the access link. Patricia, if you're there, do they need to do anything to access the link?
Yeah, so all the web links are right below. Yeah, so the link is right below in the web links box. So feel free to just click on the link and then click on the Browse To button, and that should open up the browser for you.
Thank you, Patricia. So this is a letter that was created last year by HUD, the Department of Housing and Urban Development, HHS, which is Health and Human Services, and also the Department of Justice, which is a reminder to those who are receiving federal funding to not turn away immigrants who are experiencing homelessness or victims of domestic violence on the basis of their immigration status. And so I think it's a really important resource to make sure that the service providers in your area are kind of aware of their obligations if they are receiving federal funding. All right, let's move on to VAWA. So Violence Against Women Act self petitions were created by Congress in 1994 and kind of the express recognition that abusers often use someone's lack of immigration status or dependent immigration status as a way to maintain power and control in relationships. And so it created a special process if there was a victim of domestic violence who had a certain relationship to the abuser. And that certain relationship is one based on marriage, a certain relationship, and that could be to a United States citizen, which we put there as USC, or a legal permanent resident spouse. And legal permanent resident, as you know, is also known as a green card holder, even though those cards have not been green for a very long time. Sometimes this jargon is hard to quit. So again, there's a special relationship with the abuser, that they are the spouse of a United States citizen or legal permanent resident, that they are an abused child of a U.S. citizen or legal permanent resident. And so child typically means in the immigration context, someone who is under 21. But there's an exception for filing, that you can do a late filing as an abused child of a USC or legal permanent resident if one of the central reasons for the delay is caused by the delay in filing, and one central reason for the delay is caused by the abuse. And so as we go and as I think of these memoranda, I'm kind of a nerd about these things. And so there's a special memoranda that kind of talks about this eligibility for individuals who to file for as a child self-petitioner even after the age of 21, but before attaining the age of 25. And so I will make sure that I put those web links in the materials. Okay, so there's a certain relationship to the abuse. Oh, and the last part is that if they are an abused parent of a United States citizen son or daughter, and so that typically means a son or daughter who is over 21. So there's a certain relationship to the abuser, and that abuser has a certain immigration status. That they have suffered battery or extreme cruelty, that they had a joint residence with the abuser, and that they can show that they're a person of good moral character. And that good moral character is typically a showing of good moral character 3 years before the filing of that self-petition, but the Immigration Service can look kind of beyond that if there are other issues as well. And if you're filing based upon being the abused spouse of a U.S. citizen or legal permanent resident, there's an additional requirement that you have to show that there was a good faith marriage. And so the burden of proof in these cases is the preponderance of the evidence, meaning that it's, 51% that likely that a person is, you have to prove this by 51%. And the evidentiary standard to meet that burden of proof is called the any credible evidence standard. And so that is lower than other forms of immigration benefits, and it's lower precisely because Congress, when they created these benefits like VAWA self-petitions, U visas, and T visas, realized that oftentimes if individuals are leaving abusive relationships, they're not going to be like, okay, and we need our birth certificates, and we need this document. That oftentimes there are emergency situations that people might not be thinking about these documents when they're leaving abusive relationships. And so kind of given the reality of kind of what survivors might kind of have on hand, they have the evidentiary standard of any credible evidence. But that doesn't mean that you can support, that you should submit the best evidence that you have. And the best evidence, can often be described with systems evidence. So if a person did reach out to the police for assistance, that they have a police report, if they reached out and got medical assistance, documentation from that service provider, if they reached out to community-based organizations for assistance, that organization supplies some kind of letter that there was some kind of touch with those systems because of the domestic violence. Oftentimes, for VAWAs and U visas, the applicant's declaration is the heart of the application, because that is where, in their own words, they have an opportunity to kind of describe how they meet the requirements, how there was a good faith marriage, how there was battery or extreme cruelty, corroborating declarations from counselors and others. And so in other kind of document collection, what have you done, and kind of those of you who have done VAWA self-petitions? For example, to show good faith marriage, how are some of the ways that you have shown this? How are some documents, or what could you use as supporting evidence to show that an individual entered the relationship in good faith? And what we mean by good faith is that they entered those relationships with the intentions of sharing their lives together, and they did not marry solely to get immigration benefits. So what types of things do you think that you could use to show a good faith marriage, or what have you done? Okay, we have pictures, that's great. Pictures from wedding or ceremony, pictures of family birthday parties. Pictures are really good evidence kind of showing that they have children in common are usually a very good form of showing good faith marriage. Tatiana, we're going to talk about divorce in just a second. Emails, photos, letters of people who knew them together, who've been over to their house for certain events, notes, cards, birthday cards, declarations of relatives and friends. Excellent. What about financial? Is there anything that you can kind of use, show kind of there's a good faith relationship because of those types of things? Exactly, Catherine. Joint bank accounts, insurance documents, if they have a lease together or mortgage together. Exactly, Tatiana. So that kind of enmeshment of financial resources is another thing that USCIS can look for to kind of showing about how there's an intention to establish your life together. And a lot of times, a lot of this evidence is also combined with the joint residency requirement, right? So if I pay the cable bill and my spouse pays the electric, but they show the address is the same in the same time frame, then that can be used to show kind of joint residence and that we are kind of sharing the responsibilities and expenses of the house. Exactly. So Catherine mentions a really important point, is that oftentimes that there is a lot of an economic abuse that you find in these situations, that spouses control all the accounts, they could have their names on the mortgage, they don't have allow the spouse to have access to these resources. And that's where that other evidence, in particular the declaration, is really important to show that. Because you can say, you know what, I don't have a joint bank account, I don't have these leases, because my spouse never allowed me to be on these documents. And so what I think is often helpful is to kind of cut this off at the pass and saying, okay, if you're looking for joint leases, if you're going to be looking for joint bank accounts, if you're going to be looking for maybe taxes filing jointly, that's another evidence that's usually commonly submitted, why don't I have that? And addressing why you don't have that in the declaration is a really good way to prevent what we usually get called requests for further evidence, or RFEs. So why doesn't the survivor have kind of what people would consider to be primary evidence of good faith marriage? And what you are submitting, these pictures together, these letters from your friends who know you to be a couple, how what you are submitting is credible. So this is a requirement for VAWA self-petitions and also for the domestic violence waiver for conditional residence, which we're going to talk about in just a moment. But we're going to talk a little bit about the relationship, the spousal relationship with the abuser. Because if you're applying as a child, even as a stepchild, you would need to kind of show the relationship to the abuser. And that's often through a birth certificate, or if you're applying as a stepchild, kind of the marriage certificate and the birth certificate kind of showing the stepchild relationship. So Tatiana, yeah, and I guess the question is kind of what evidence you're submitting. If the abuser kept a double life, if you submitting documentations that would affect the credibility, I wouldn't necessarily think of submitting documentation, that would somehow kind of damage the credibility of my client. And so Tatiana, if you want to talk to this, my email's at the end, and we can talk a little bit later about that specifically. So spousal relationships, common law marriages, it could also be proof of abuse, kind of saying, especially if the survivor, didn't know about it. Their common law counts if you are in a state that recognizes common law marriage. I think that there's actually maybe 9 jurisdictions and the District of Columbia in which common law marriage is recognized. And so if you're in one of those states, I think it's Texas, New Hampshire, Iowa, Colorado, Iowa, and sometimes it also depends on the date in which you're kind of establishing the common law marriage. So I think it's also just good to know whether or not in your state, whether or not common law marriage is available, and if so, that it can count for purposes of VAWA. The rule in immigration law is that a marriage is valid if it is legal where it took place. You are also allowed to file for VAWA within 2 years of a final divorce order. And you can also apply if there was bigamy by the abuser. And what that means is that if a survivor thought that the other person was free to marry and there was a ceremony, but in fact there was no actual prior divorce from the former spouse, that as long as kind of the person who was applying believed that that marriage was valid, then you can still apply in those situations. That's normally known as what they call an intended spouse. And so what are ways that you can show an abuser's status? How would you be able to show that someone is a U.S. citizen or legal permanent resident? Does anyone have any ideas? Yep, affidavits if you can't find documents. I know that my spouse is a naturalized citizen because I attended their naturalization ceremony and they held the flag and it was a very happy event. Taxes, sometimes marriage certificates have a place of birth. Birth certificates, passports, copies of the green card. And you can also, through these affidavits, you can also ask that USCIS potentially electronically verify their immigration status and providing them with as much information as you have. For example, providing the date of birth, providing a social security number, and you can also, if the person themselves is maybe a legal permanent resident or a naturalized U.S. citizen, asking USCIS, which is the Immigration Service, to the A number to electronically verify the immigration status. That's good to know, Tatiana. I didn't know that my name, so some state licenses have a place of birth or the immigration status. This is great. Kind of figuring out what other kind of secondary evidence you would have, which might have a place of birth or kind of the immigration status that's listed on an official document. That's very good to know. All right, let's move on. All right, battery or extreme cruelty. So for example, Tatiana kind of talked a little bit about kind of economic abuse. What other kinds of domestic violence do you see that are not physical violence? All right, sexual exploitation, financial. Elder abuse, so maybe that's for kind of the abused parents of U.S. citizens, psychological, emotional. Exactly. And what kinds of things do you think you could use to show battery or extreme cruelty in VAWA cases? So what kind of supporting documents, what kind of paper would you use to support this? Right, so mental health documents, if someone is seeing a therapist or someone is seeing a counselor. And again, we have templates that are on our website, and I'll put on here, that is not kind of a verbatim, but it kind of outlines, paragraph 1 should explain how a person is qualified to be talked in or has expertise in domestic violence, and talk a little bit about kind of what the survivor has told to that professional and how that story kind of comports with their knowledge and expertise in domestic violence. So I think making sure that that kind of says that this is my expertise in domestic violence, this is the client's story, and here's that analysis, and here's how that fits together, are really, really helpful in terms of making the declaration that's going to be effective documents for you, especially in kind of extreme cruelty spaces. So medical records, right? If there is physical violence, pictures of that, police reports, Again, and supporting affidavits. If there are neighbors, if there are friends who can know about or to whom the victim has reached out to about kind of the battery or extreme cruelty, to having those declarations as well, in addition of kind of talking a little bit about in the applicant's own personal declaration, what's happened. And just kind of a quick note, especially I think in cases where you do have cases based on extreme cruelty, kind of thinking about our power and control wheels for a moment, and thinking about all of the things that we can kind of constitute as that emotional, psychological abuse. Things like insults and put downs, and all of those things that we can kind of putting together kind of lead to or amount to that kind of emotional or psychological harm. If a client is doing their own declaration, saying not only something like, my spouse used to call me names, or my spouse used to call me X, Y, and Z, to kind of follow up that question, okay, when your spouse called you X, how did that make you feel? Because that how do you make you feel is really how you get to kind of the emotional impact of how what was said or how what was done. When the abuser threatened to call the police because she was undocumented, how did that make her feel? Or how did that make him feel when that happened? Good moral character. Sometimes, and how many times I've worked with clients who have been arrested or have been convicted of a crime. You can raise your virtual hands. All right, so a few of you. And has that crime been connected to being a domestic violence survivor? Yeah. And so there's another memo that I would encourage you to look at. It's one of the first ones. It's called the VAWA Good Moral Character Memo. And that, I think, is really useful to kind of think about that if there is a good moral character issue, is there a nexus to the abuse? If there is, as Tatiana mentioned, economic control, and a survivor was maybe arrested for shoplifting, there's an argument to be made that the criminal history is connected to the abuse that was suffered. And so I really encourage you to kind of look at that good moral character memo, see when it would be in effect for what types of issues. Again, this is commonly proven by police clearances for the individuals where the people have lived for more than 6 months. And if there are any issues or any kind of criminal issues, is the question to ask is there a nexus to the abuse that they have suffered? And again, that in terms of, sex workers maybe in the context of trafficking. And if we're dealing with other forms of inadmissibility, this kind of nexus analysis is really important because, but for the victimization, they might not have had this issue in the first place. So I really encourage you to look at that VAWA Good Moral Character memo. It's one of my favorite memos, if it's possible to have such a thing. And I know that you all have one too, so don't act like you don't. And we will, again, if any kind of issues that you see coming up in your cases that you think might have good moral character or in the future inadmissibility issues, we can talk through kind of the details of those through individual technical assistance. So why go through this at all? Why go through this process? You go through this process because it is able to put you on a path to legal permanent residence. Oh my goodness. Something exciting is happening on the screen. To do it, not to rely on abuser for an immigration benefit. It basically kind of subs out that family petition process for one in which an individual is able to do it by themselves and not have an immigration benefit rely on an abusive spouse or an abusive parent or an adult U.S. citizen child. There is a special unit that looks at these cases, so it's not like these cases are going to be, put in front of a person who does not have expertise in the dynamics of domestic violence. And that in they need public benefits and they're available, you can get it with a prima facie determination. Once the VAWA self-petition is approved, you are eligible for work authorization, or you can get it during the pendency of the application if the abuser is a U.S. citizen. We'll talk a little bit about that more in a moment. And you can include derivatives, minor children both in the United States and abroad. And that, yes, we talked about these. And there are kind of special inadmissibility waivers for VAWA self-petitioners. For example, if you have maybe unlawful presence issue or permanent bar, kind of whether you can show that those entries and exits were connected to the abuse. So there are, especially that VAWA Good Moral Character memo does, I think, a good job of indicating those, that there are special waivers of inadmissibility for VAWA self-petitioners as well. So the process is different if the abuser is a United States citizen than if the abuser is a legal permanent resident. If the abuser is a United States citizen, you're able to file the VAWA self-petition at the same time as your application for your green card, or it's called adjustment of status. And once that application for your green card is filed, you might receive work authorization while all of that is pending. And in general, it's a faster process. If the abuser is a legal permanent resident, then you can get work authorization when the self-petition is approved, and you must wait until the priority date is current to file for your green card. And sometimes you might have cases where a spouse filed an I-130 or a family petition, and if that is the case, then you can use the priority date of that previously filed application for your VAWA self-petition as well. But again, if you're filing for an application for your green card at the same time as the VAWA self-petition, you really need to make sure that you are screening not only for just good moral character issues, but also for inadmissibility, and making sure that there are not going to be any problems after you submit these documents. So there's that kind of two-part analysis. One, screening for kind of criminal and immigration history as it relates to good moral character, and doing that same analysis if you have an application for your green card or your legal permanent residency, making sure that you're hitting both of those marks. So this is the process for a waiver on the joint filing requirement for conditional residency. Are folks who are familiar with this process already? You can raise your virtual hands. A few. Okay, great. So, for those of you who are not, residency is conditional if the immigrant spouses and their minor kids obtain their green cards less than 2 years after their marriage to a United States citizen or legal permanent resident spouse. So if you're married for less than 2 years before you get your green card, if it's based on a marriage, then you have to apply jointly to remove that condition on your green card in order to receive a full 10-year permanent residency card. And that's done because immigration wants to see for a second time that they entered the relationship in good faith. So assuming if you've been married less than 2 years before you get your green card, you get a 2-year green card. And then after that, before that period, you would file jointly with your spouse to remove those conditions, and you would submit evidence that you had a good faith marriage. But in recognition of the fact that that joint filing may not always be possible, in 1990, Congress created these waivers to the joint residency requirements in cases of a divorce, death of the spouse, domestic violence, and extreme hardship. And so to show that there's a domestic violence-based waiver, you have to show that they entered the relationship in good faith and that there was battery or extreme cruelty. And so that is the typical, And so that is, again, the credible evidence applies. So it's very similar to a VAWA self-petition, that you would need to show good faith marriage, and you would need to show the evidence for battery or extreme cruelty. And again, this is a way that you can proceed with the removal of the conditions on your green card without without having to rely on an abusive spouse. And if it's approved, then you get a full 10-year green card. So where and when to file these waivers depends on where you live. As they're processed both at the Vermont Service Center and also at the California Service Center. So you would need to look at kind of the instructions on the website to see which place, and it's based on the state that you live in. Sometimes there are interviews that are in person at the district office. And you can include minor children if the minor children themselves are conditional residents. And so what happens if you filed a joint waiver, but that joint waiver was denied and there was domestic violence? You'll be able, or you can also file based on a waiver if you have one of those conditions, if there is divorce, domestic violence, or the death of the spouse, or extreme hardship. Sometimes we have cases where they file both on divorce and domestic violence. And if that is the case, then you can tell the Immigration Service how you want that application decided. That you want it first considered on domestic violence and secondarily on divorce. Does anyone know why that matters? What is the basis on which the conditional residency is filed? Does anyone know why that matters? All right, cool. I'm going to tell you. It matters because if the waiver was based on domestic violence, yes, Tatiana, if the waiver was based on domestic violence and there was a marriage to United States citizens, then the survivor can apply for their green card in 3 years instead of the regular 5. But that's only in cases where there's a domestic violence approved waiver and not in divorce or any of the other bases. So that's why it matters. And if individuals are in removal proceedings, they still have the ability to apply for these applications. So we have a little hypo here, and we have Soli. Soli is a conditional resident who is married to her U.S. citizen abuser. Her son, Christian, was also abused by his stepfather. Christian is not a conditional resident because her husband refused to file papers for him, part of the power and control over Soli. So I have a poll now. Patricia, do we have it up, or do we just have it like where people would apply? Patricia? How would you file? Would you file a 751 for Soli with Christian as a derivative? Would you file a waiver for Soli but a I-360 for Christian? Or would you file I-360s which are VAWA self-petitions for both of them? So again, the 751 is for conditional residence, and the I-360 is a VAWA self-petition. So again, let me just review the facts with you. So we have a situation in which Soli is a conditional resident married to a U.S. citizen abuser. So she's being abused by her U.S. citizen spouse. And her son is also being abused by the stepfather, the United States citizen. Christian is not a conditional resident because her husband refused to file papers for him as part of the power and control over his wife. So Soli is a conditional resident and Christian doesn't have anything. All right, we'll give folks another minute. And so those options again is a domestic violence-based waiver for the conditional resident for Soli with Christian as a derivative, a domestic violence waiver for Soli, and a VAWA self-petition for Christian, or you do VAWA self-petitions for both of them. All right, we're going to another 35 seconds. All right, we can close the poll. Okay, so 44% of you said waiver for Soli and the I-360 for Christian. Of those folks who said B, why would you say B? Cecelia is a conditional resident, right? So she already has her 2-year green card. Can we go back to the, okay. Can we go back to the, all right, thank you. All right. Cecelia is a conditional resident, which means that she obtained her green card, but she was married to her abuser for less than 2 years. So she already has a 2-year green card. But her son, who's also abused, is undocumented, or at least not a conditional resident, because the stepfather never filed paperwork for him. So they're in 2 different positions. So Soli would need to do the domestic violence waiver, to showing that she had entered in the relationship with her abusive spouse in good faith and that there was battery or extreme cruelty. So Christian can apply because he's the abused child of a United States citizen. And so for him, he would file his own VAWA self-petition on the basis of being an abused child. And for that, he would have to show joint residency, he would have to show the relationship with his stepfather, and he would have to show the abuse or extreme cruelty and good moral character. So the 751 is to remove the conditions, and the I-360 is the VAWA self-petition that he would use to file for his own application because he was not in the same place as his mother. Does this all make sense? Any questions about this? Right. So Melissa's totally right that he doesn't have any status yet and he should file an I-360. We don't know how old he is, but if one of the reasons for the delay is this domestic violence, then he should file before he turns 25. Absolutely. Good point. All right. Let's move on. Any other questions about VAWAs as self or conditional residence? Yes, exactly. All right. So let's talk about U visas. U visas were also created by VAWA in the 2000 reauthorization. There are 10,000 visas available annually, and there's a wait list for those who are who would have received visas but for the cap. And the purpose of creating these U visas, which I think is important to start here, it's important to start with why these applications were why these benefits were created in the first place. And that is to strengthen the ability of law enforcement to investigate and prosecute criminal activity, and to offer protections for the victims who are coming forward to report this crime. So it has a dual purpose. It is a tool for law enforcement and created with the recognition that it is often difficult for especially undocumented immigrants to come forward to report these crimes because of the fear of immigration enforcement. So this is the purpose of creating these benefits to begin with. The requirement is that they suffered substantial physical or emotional abuse because they were a victim of a qualifying criminal activity. And it's important to kind of think of these criminal activities that are listed in the statute as categories of crimes. For example, if you have something that, a relationship, a dating relationship, and there's, someone was convicted of maybe slashing the other person's tires, right? That's a destruction of property, but in the context of interpersonal violence, is there a way that you can potentially kind of frame that as domestic violence related crime? So the survivor was, or likely to be helpful to the law enforcement prosecution, to law enforcement or to a judge or to another authority investigating the crime, investigating or prosecuting the crime, that a crime occurred in the United States or otherwise violated law, and they're admissible or they otherwise qualify for a waiver. The benefits of the U visa is that it gets 4 years of status with employment authorization. You can include derivative family members both in the United States and abroad. That after 3 years of showing continuous physical presence, you can apply for your green card. It has an extremely generous waiver under 212D4, which basically is potentially waives any ground of inadmissibility, with the exception of being a Nazi or a genocide perpetrator. And in a few states, I know in California, you might be eligible for public benefits. The U visa certification is essential to the filing of a U visa. You cannot go anywhere. You cannot pass go if you do not have a U visa certification. And that can certify, so certification basically does three things. It certifies that a qualifying crime occurred, that the applicant was, is, or will be helpful, and that the crime violated U.S. law. So does the U visa certification have to prove the harm that they've suffered? No, it doesn't. That's not one of the things it has to show. It has to, so basically the certification does those three things. Issues about inadmissibility, issues about harm are determined by the U.S. Citizenship and Immigration Service. So if you get pushback and saying, oh, there's not really any harm in this case, and be like, okay, that is for us to show. And so a really helpful link, if you haven't used this already, is the DHS Law Enforcement Certification Guide. And that has a really good Q&A section about kind of whether or not there's a statute of limitations, what if the applicant themselves have a criminal history. And it does a pretty good job of showing that those are issues that are decided by USCIS. You know, the giving of a certification is not an issuance of a visa. It is merely a step in the process. And I think oftentimes that is confusing for law enforcement, that, oh, if I give you this, I give you a visa. No. And I think even some media stories are kind of confuse the issue a little bit. But the certification is a central step, but it is not by itself enough to kind of show the requirements of the U visa. Which agencies can certify? You have federal, state, or local law enforcement, federal, state, or local prosecutors, and federal, state, or local judges. And you have other state or local or federal agencies that investigate qualifying crimes. So that can mean a federal or state Department of Labor, or other agencies like Child Protective Services, the EEOC, the National Labor Relations Board. And so has anyone had a U visa certification from one of these kind of other agencies, maybe kind of Child Protective Services, or from a judge? The most common ones that you see are usually kind of local law enforcement, police, sheriff's office, or a prosecutor's office. Those are probably the most common. But there are kind of a more expansive view of what a certifying agency can be in the investigation. Like, for example, in New York City, I know that the Human Rights Commission can be a certifying agency in their investigative process. Who can certify? Generally, the head of the agency, or a person who's in a supervisor who is specifically designated by the head of the agency to sign. And if the certifier is new, kind of having that letter from the chief or the supervisor designating that person as a certifier. Or a judge who can detect a qualifying crime in the course of the proceedings. So this can be a criminal judge, or oftentimes there's also judges that have issued certifications in protection order cases if they detect that a qualifying crime, like an intrafamily offense, has occurred. Again, this is going to be jurisdiction specific because the decision to sign these certifications is completely within the discretion of the office. And so that's why you have so much discrepancy in between the certification practice, because, you know, if you're a victim of a crime in one jurisdiction, you know, the next town over, if you're the victim of the very same crime, might have a different process in which they do this. This webinar would not be complete without the prerequisite charts of all the U visa crimes. So here's what you have in the context of the work that we do: rape, sexual assault, abuse of sexual contact, domestic violence. And again, you know, thinking of these as these crimes as categories. You know, for something like the destruction of property in the context of an interpersonal relationship, is there a way to potentially frame that as domestic violence? Also, something to think about is the workplace crimes. I think, you know, we're typically used to thinking about abuse in the context of interpersonal relationships, But how many people ask whether or not there's any problems in the workplace? Does anyone kind of include those questions in their intakes? And it's kind of identifying whether or not there's potential, sexual abuse, sexual violence, abusive sexual contact in the workplace. So making sure that if that's not already kind of an issue on your radar screen, to start asking about these, because that could kind of have a different conversation. So some things that happen in the workplace, obviously sexual abuse, issues of false imprisonment, felonious assault, involuntary servitude. And also you have instances in which employers try to thwart investigations. And that's where you get the qualifying crimes. Yes, Tatiana, Rape on the Night Shift is an amazing documentary on this issue. So blackmail, witness tampering, obstruction of justice, perjury. Because oftentimes, when you're just starting out in this work, you're like, why are these, UVs a crime? And it kind of talks a little bit about that's where these mostly come in, is kind of the thwarting the investigation. So if you don't already ask about issues in the workplace, I encourage you to start doing so. Who's the victim in the U visa context? The easiest way is the direct victim is someone who was proximately harmed by the crime. Oftentimes sometimes people say these bystander cases, and the example they give in the regulations is that a pregnant woman who witnesses a murder who miscarriages because of the shock of witnessing this crime. And so bystander is a form of direct victim. It is not by itself a separate category. These cases are extremely rare. And if you have something that you're considering before you file, I 100% recommend that you check in with us, because it can be very, very hard to frame and hard to win. If the direct victim actually was murdered or a victim of murder or manslaughter, then potentially the spouse or children who were under 21 and unmarried can be considered an indirect victim. And if the direct victim is a minor, then an indirect victim could be the parents and siblings under 18, and the victim's age is measured at the time of the crime that it occurred. So, for example, if you have a child victim of sexual assault, the parents can apply as an indirect victim, but they would also have to show that they hit all the requirements of the application, that they were helpful in the investigation, that they themselves have suffered harm as a result of this qualifying crime. So even if the direct victim is under 21, parents can apply as indirect victims, but they would need to hit all the requirements in the same way as the direct. Who can be a derivative? Who can gain benefits? If your survivor is over 21, the children and spouses can be considered derivatives, with a caveat that you cannot file for an abuser or a perpetrator of a crime. So if you're filing a U visa based on domestic violence, you cannot file for the abuser as a derivative of the application. The child age is frozen on the date that the principal files the application. So even if a child turns 21, as long as the application was filed before the child was 21, then that would kind of have those protections. And if the survivor is under 21 years old, they can include their own children, spouse, parents, and sibling under 18 as derivative beneficiaries. So the process now is that you get work authorization once you're placed on the wait list, that you can get work authorization for 4 years once your U visa is granted, and that there is a part of the statute which is at INA, the Immigration and Nationality Act, 214p6, and that talks about making bona fide determinations and issuing a work permit after making that bona fide determination. Right now, they are not implementing this process, but it is in the statute, and I can talk to you more about that after the webinar, because it gets a little complicated. So the benefit of the U visa. If you get a U visa, you have 4-year work authorization, the potential for family reunification, and the ability to become a green card holder after showing 3 years of continuous presence. But there's this wait list. And the wait list, if you are on the wait list, it gets you a 2-year work permit based on deferred action. And your family members abroad, there is no way for that family reunification to occur pursuant to the U-Visa system. But you can use the humanitarian parole option if you think that it could potentially qualify under the statute for humanitarian parole. And so that is at 212D5, INA 212D5, which talks about the granting of a parole is showing a significant public benefit to the United States or in emergency circumstances. So this has worked before for U-Visa, potential U-Visa derivatives abroad. For example, if there was an emergency, medical issues, if there was threats of gang violence. This is a way that people who are on the wait list have been, in a case-by-case basis, eligible to have that family reunification piece while they were on the wait list. And the time that they spent with deferred action does not count towards the time of continuous presence for adjustment. So you could have a 2-year work permit for deferred action. You could have another 2-year work permit. So you could be deferred action for however many years, but the clock only starts for your eligibility to adjust once you have that full 4-year visa in hand. So there's a big discrepancy in terms of the benefits of the wait list and the actual benefit of the U-Visa grant. And I'm telling you this because, as you know, that even before you're on the wait list, there is a significant backlog in the processing of U-Visa applications. And U-Visa applications are processed at the Nebraska Service Center. There's about 24 adjudicators at the Nebraska Service Center, and also at the Vermont Service Center. These are the places where they have the specialized units looking at the U-Visa program. And in total, you have about 60 adjudicators, more or less, who have this U-Visa workload. And so right now, if you check the processing times on the immigration website, you will see that they are working on applications that were filed on August 25th of 2014. So that means if you filed your application after that date, your file is there waiting to be opened. And so the August 25th, 2014 date is the date that they're going to be considering for placement of individuals on the wait list, and not for the issuance of the full 4-year visa. So all of those from August 2014 to December 2017, all of those folks are just waiting to have their file opened, waiting for their case to be considered, even for placement on the wait list. And so a lot of people are concerned about this. They're concerned about this because it is an extremely long time. If you are in an abusive relationship, it provides no work authorization by virtue of these cases being just pending. There's no family reunification component by virtue of having an application pending. And the protection from removal is also a really big concern. And what if someone is put into removal proceedings? And so I think all of these are open questions right now. I think that the policy on this and how U-Visa holders will be treated after they're arrested by immigration officials or in detention or in removal proceedings. If you've seen these cases, please reach out to us, because it is it's a very long wait even to have your file opened. And in preparing for today's webinar, I found out that there is a new U-Visa data set, so go ahead and click on that link for the U-Visa data set, because I'm going to make your lives a little bit more depressing. So there's a new U-Visa data set that was released December 7th, and what they said in that new U-Visa data set is that there are 110,000 pending principal applications and over 190,000 pending total. That's inclusive of derivatives. So that 110,000, the cap only applies to the principal applicants and not to the derivatives. But at the moment, it says that there's 110,000 principal applications, and there's 60 adjudicators working on this case. Do I still think it's worth filing? Yes, I do. But it's severely and substantially and significantly backlogged. And so I think it's just important at the outset to give people a sense of what it is that they're looking at and what the process is and what the processing times are. And so that is why kind of doing that safety planning in the interim is really important because of the significant backlog. Can't talk about that, Kathy. This is an OVW webinar. Okay, so we'll move on to T visas. T visas are for victims of human trafficking, and it sounds like, Tatiana, you might have some experience with some T visas, so I might kind of check in with you. T visas are for victims of severe forms of human trafficking, which actually begs the question, which form of trafficking isn't severe? So that they're a victim of severe form of trafficking, sex or labor trafficking, that they're physically present in the United States or at a port of entry on account of the trafficking, that they have complied with reasonable requests for assistance if they're 18 and over, that they would suffer extreme hardship if they were removed from the United States, and they're admissible or eligible for a waiver. And so when we think about kind of commercial sex trafficking, that what we think is that there's a use of force, fraud, or coercion for the victim to perform a commercial sex act, or if the victim is under 18 years of old, full stop. There is no need for a showing of force, fraud, or coercion if the victims are minors. And that for labor trafficking, what we see is kind of the process, which is the recruitment, the harboring, the transportation through force, fraud, or coercion of that forced labor for involuntary servitude, for debt bondage, slavery. And this is something that we see in a variety of different fields, from domestic workers to restaurant workers, agricultural workers, hotel. And so this is something that can happen in a myriad of different kind of fields and not just kind of one or the other. So it's important to kind of know that it can kind of take place in a variety of different kind of environments in the labor trafficking context. So if you're screening for trafficking, and I think it's really interesting to kind of think about trafficking in the context of domestic violence, because oftentimes people can be put into trafficking situations by an intimate partner. And so even if we are primarily a domestic violence service provider or sexual assault service provider, that there is kind of an overlap between these different forms of, excuse me, before these different forms of immigration benefits. And so, I think it's important, if you don't already, to incorporate these red flags into your intake process. For example, you can ask whether abusers forced or tricked them into working long hours, whether or not the abuser was an employer, whether or not they could feel that they leave the employment situation, whether the abuser controlled their identity documents. And so these are just some kind of red flags. Do they have their identity documents? Were they recruited to come to the United States through false promises? For example, maybe there's a case in which someone is coming on a fiancé visa and forced to work in an employment context. So was there any kind of, maybe they were recruited to come to the United States for false reasons, owes a large debt, not allowed breaks at work. So again, you can look at these issues in conjunction with maybe a U visa, like we talked about before in the workplace context. So asking these questions as well, because we're asking about what's happening in the workplace context, incorporating these as well, because if you're looking at the difference for a U and a T visas also have a cap of $5,000 annually for principal applicants, and they have never hit the cap. And for U visas, the cap has been hit every single year since 2009. So if you have something that could potentially be framed as a trafficking case, then if you're looking at it in conjunction with a U visa, this might be a faster way to go if you can hit the requirements of the visa. Also, for the T visa, when you are complying with reasonable requests for assistance, this can be shown through secondary documentation. There is a declaration, which is akin to the law enforcement certification in the U visa context, but it is not a requirement in the same way that it is in the U visa world. So you can show by secondary evidence that the person was willing to comply with reasonable requests for law enforcement through kind of emails back and forth with the investigating agency, through showing that they went to interviews, or that pictures were taken, or that so this can be shown, this helpfulness requirement can be shown by secondary evidence and not necessarily the kind of formal declaration from a law enforcement official. So I just wanted to mention that as well. For the T visa benefits, you get a full 4-year visa, work authorization once it's approved. You can apply for your green card after 3 years, or if the Department of Justice certifies that the investigation or prosecution has concluded. And you can include derivative family members as well, including family members that kind of go beyond what you can in the U visa context. So we have a few more hypos to kind of wrap all this up. And I think I might get you out of here in less than 2 hours. So we will try to do this, but at the same time making sure that I answer all of your questions. We have Angelina, who's 19, and was brought to the United States by her father when she was 14. Her father physically abused her, forced her to work in his restaurant where he didn't pay, forced her to sleep on the floor, took all of her identity documents. She was able to leave when she was 18 and comes to your office for help. What don't we know? What facts are missing that would be useful to know if we're talking about her immigration benefits? Right. We don't know, Cassie said, is the father a United States citizen or an LPR? Right. We don't know the immigration status of dad. And why is that important, Cassie, or anybody? Right. To see whether or not the option of a VAWA self-petition is on the table. Whether or not we can know whether or not Angelina could potentially qualify for a VAWA self-petition by being an abused child of a U.S. citizen or legal permanent resident. Okay. So what do we think might some options be? Let's say that dad is a legal permanent resident. What do we see as options? He or you. And so, Tatiana or anybody, what elements of T visas do you see here? Why would you consider T as potentially being able? Right. So Cassie says she was brought to the United States, she was underpaid, no access to the documents, withheld her ID. She slept on the floor of the restaurant. So we have some kind of forced work. And what do we see for U visa? What do we think that could be the potential qualifying crime for a U visa? Right, child abuse. Right? Maybe we have a false imprisonment claim. We have maybe domestic violence that we have here in terms of an interpersonal relationship. Right, and so, and if we know that dad is a U.S. citizen or LPR, it could be VAWA, right? So this is one of those cases where you would say, like, okay, maybe there's room for all three. And if the father was not a U.S. citizen or LPR, and if we're looking at T visas or U visas, let's say that we can show they're eligible for both. What would your first pick be? Yeah, Karen would be a T. And why would you do that first? Right, because it's faster. And so, again, you might have a case where you have someone who's eligible for more than one form of relief, and that is actually magic. And what happens in those situations is that you would instruct the Vermont Service Center. You would say, okay, we want the T visa to be adjudicated first, and then, and in the alternative, if that's not approved, then we want the U visa to be looked at. So you can apply for more than one thing at the same time, and but you would have to kind of withdraw the U visa application if the T visa were approved, because it's important to do that so that someone else can get in line. So Tatiana asked an important question: do you need separate forms? Yes. The U visa forms are the I-918 forms, and the T visa forms are 914. So there's different applications, different instructions, and if you're kind of thinking about filing for both forms of relief, and if you have any other kind of more practice questions, definitely feel free to hit me up after the webinar. All right. We already talked about that. We're talking about special immigrant juvenile status. The eligibility for that is that you are unmarried and under 18, and that sometimes that goes up to 21 in certain states, and that the juvenile court has jurisdictions or has assigned custody and makes a finding that reunification is not viable with one or both parents due to abuse, neglect, or abandonment of the child, and is not in the best interest that the child be returned to the home country. And yes, there is a waiver available in the T visa context, which is done on the 192 form. There is a little bit difference in terms of the statute that applies, but we can put, when we kind of go to the question period, I'm going to flag that Melissa for something to come down here. So the SIJS is a two-part process. One, you have to have this kind of family court proceeding where there are these findings, which says that there has been abuse, abandonment, or neglect with one or both parents. So you can have one abusive parent and another one who is not, and ask that custody be granted to the non-abusive parent. And so this is a way, kind of upon that finding by a juvenile court or a family court, once those documents are submitted, you also use the I-360, which is kind of the VAWA self-petition form, to apply for special immigrant juvenile status. Has anyone been familiar with this special immigrant juvenile process? You can raise your virtual hand. Okay. So for special immigrant juvenile status, it does not have beneficiaries. So if you are unmarried under 18 and maybe you yourself has a child, that by itself cannot extend benefits to minors or to parents. And also, if you have your legal permanent residency on the basis of SIJS, that you cannot, in the future, file an I-130 for your non-abusive spouse. But that's not an option. But it is a way to kind of apply for your green card if there has been abuse, neglect, or abandonment by one or both parents, and that there has been kind of assigning a custody or guardianship to either a third party or the non-abusive parent. The gender-based asylum, if people are entering the country because they are fleeing domestic violence abroad, it's worth asking kind of why people decided to come to the United States. Gender-based asylum is if you have a well-founded fear of persecution or have suffered past persecution on account of your race, political opinion, your religion, nationality, membership in a particular social group. And there was a case from the Board of Immigration Appeals a few years ago for a matter of ARCG. And what that case said that is married Guatemalan women who are unable to leave their relationships because of domestic violence constituted a particular social group. And so that there's kind of this emerging kind of gender-based asylum case law on the basis of domestic violence. And there's been cases that have been approved where you didn't necessarily have a marriage, but that have been kind of decided when there has been elements of domestic violence. and that they cannot safely or reasonably relocate within their home country. So we have this last typo. We have Inez. I don't know if this is the last one. Maybe it is. Inez came to the United States with her infant son, Rafael. She escaped domestic violence, I would say, from her son's father, who was also abusive to the child. Inez was also a victim of felonious assault in the United States. What do you think? You in asylum. But we also have the issue for asylum is we have a 1-year filing deadline, right? And we have to show that there are extraordinary circumstances why the application for asylum was not filed within that first year of living in the United States. So it requires an additional element. It is kind of showing kind of the exceptional circumstances why it wasn't filed within that first year. And then the kind of the U visa. So I think this is something to think about. If an asylum application is denied, then it's referred to the immigration court, where they have an opportunity to present the case again in front of the immigration judge. So here you need to think about kind of what is the road. Right now, if a U visa application is denied, then it doesn't get referred to immigration court. But you have to think about, even if there's potential case for asylum, here you might have a 1-year filing deadline, and kind of showing that if that case is denied, then they could potentially use it in proceedings. And so I think part of what we need to think about is kind of what is the posture of the case? What is kind of the ramifications if it doesn't go the way we want? So potentially maybe she's already in removal proceedings, and if that is the case, then she has nothing to lose necessarily by filing for asylum. But it's important to kind of think about in terms of what the road is and what the consequences are if the cases don't work out. And again, I'm just saying what things are like as of today. And, it's hard to say kind of if that's going to be the same. I want to talk about inadmissibility for a moment, because inadmissibility applies in the VAWA context when you're applying for your green card. It applies in the context of U visas and T visas. And so, and it's relevant both in terms of the application, if you're talking about the U visa or the T visa, or if it's relevant as adjustment if you're talking about the VAWA issues. And so what kind of issues have you seen in your own cases when you're talking about inadmissibility? What are some of the things that you've come across in your own cases? Okay, so Tatiana has had it come up where, Cassie, I see your question, and I'm definitely going to talk about it later. Tatiana, sex work, prostitution, shoplifting for basic needs, so potential kind of crimes involving moral turpitude. Anything else? Any other inadmissibilities that you've come across? Okay, so unlawful presence bars, permanent bar issues, yeah, so misrepresentation of a right, so these are all kind of common issues. False claim to U.S. citizen, which is very important to know in the VAWA context because there is no waiver for false claims to U.S. citizenship in the VAWA self-petition process. So that might be something that you see that kind of kicks you over to the U visa world, right? And so sometimes you have things that are a full stop in the VAWA context, and that's when you might need to go into the U visa to see whether or not you could obtain a waiver based upon 212D14. Okay, so now we have Sarah. Sorry, it wasn't the last hypo. You thought you got off easy. Sarah is a victim of domestic violence at the hands of her United States citizen spouse. Oh, I just gave you the answer. She called the police, testified against her spouse, and he was convicted of domestic violence. Sarah once put that she was a U.S. citizen on an I-9. What do we think about this? What would you file for her? Just the I-360? Would you file an application for do the one step because she's married to a United States citizen? Would you do a U visa? Would you file just the I-360 and the U visa? What would you do? Okay. We can close the poll. So a lot of you, 8 of you, 57% said U visa. And U visa, I think, is out of concern that there is a false claim to U.S. citizenship. And so the other time, so you can file, so the I-360, you have to see whether or not this is something that could potentially kind of fall into a good moral character bar. And so that's something that you would need to see whether or not this is an issue that would be a bar under INA 101F. If you're concerned about the inadmissibilities issues that was raised, kind of the I-360 as a standalone basically kind of just gets you deferred action. And it doesn't itself lead to kind of a more formal status. The U visa, even though it is significantly delayed, is a visa that does have potential long-term benefits, which kind of eventual legal permanent resident status, and after 5 years with your LPR, you can apply for citizenship. So it is something that doesn't kind of just leave you in a limbo. So I think that is the difference of, whether or not why the U visa in this case might be the better option. All right, we can close the poll. Thank you, Patricia. All right, so you checked Sarah's I-9, and she didn't put that she was a United States citizen after all. You are in the clear. Okay, so here's the situation. Sarah first entered the United States in 2001. She got married and the abuse started, so she left back for her home country in 2003. So her spouse apologized, said this time was going to be different, but she re-entered in 2004, but the abuse continued. So if there's no fraud and we have this fact, would that change what you filed for her? What do y'all think? Catherine says that it would change. How would it change, Catherine? You would do a one-step. Okay. But what about all this entering and exiting? What are we concerned about this? She was in the United States for more than a year, and then she left. So she triggered the unlawful presence issues. And then she came back in after being over a year abroad. So we have some other 212A9 issues. Right. So here we need to see whether or not there's a VAWA-specific waiver. And whether or not there's a VAWA-specific waiver, which you can find at 212A9, whether or not the entries and exits were related to the abuse. So these still raise inadmissibility issues. They raise kind of potential unlawful presence, potential permanent bars since she was in the United States for over a year. But you can file those waivers because it seems in this case that those entries and the exits were related to the abuse. And so there is a process by which we kind of establish kind of doing the inadmissibility forms at 212. If you do have a permanent bar issue that's related to the abuse, then you can file the inadmissibility waivers in the I-601, the I-212. And at ASISTA, we do have a process by which we can help you navigate this in your filing. So if you find out that you do have a VAWA-related permanent bar issue, please do reach out to us because we have kind of an internal process established to make sure that your district office is kind of well-versed and know what they need to know to process these permanent bar applications. Okay, so there were some questions that came up, so if you give me a moment to for me to go to Cassie's question. Cassie, so you said you're part of a law enforcement agency. Thank you for being on this call, which certifies for U visa cert. And so you have run into issues where a survivor is applying or using someone else's SOCH. And so I want to, first of all, recommend that you look at the DHS Law Enforcement Certification Guide. Cassie, can we put that in the web link? Can I put that in the web link? I don't know how to do that. I'm going to put it right up here. And then Cassie's going to, or I'm sorry, then Patricia's going to put it in the web link because she's amazing. But I am going to recommend that you kind of look at the U and T visa certification guide because it does talk about instances about kind of these certifications in these other situations, whether or not the survivor has his or her own criminal history, what does that mean? And again, I would point back to, providing reasonable assistance. And so the U visa certification itself really needs to say three things. It needs to say whether or not there was a qualifying crime, that there was helpfulness, and that the crime itself violated U.S. law. And it also kind of talks about if there's any going to be liability for future conduct with someone who's granted a U, what is the certification who later commits a crime, and that they're not held liable for the future actions of the victims. And that there's also a way that you can reach out to someone at the U visa if you have any questions. There's an email address for law enforcement specifically that you can reach out to Immigration Service. But in general, the certification itself is kind of those three things. It's talking about if there's a qualifying crime, if they had information about the crime occurred, and that it violated the law. And so please take a look at that. I'm happy to answer any other questions or kind of connect you to someone else possibly within CIS if you want kind of more formal answers to that question. So I don't think it precludes it necessarily because the certification kind of does those three things. Cassie, is my email address here? Let me make sure that I give it to you. And yes, IRLC does have a really good guide. But here is my email address, and email me after it. I can make sure that I can get you connected. You are very welcome. There was another question that I didn't answer. I'm sorry I don't see it, but if you have any other questions, then I'm available to answer them now. And in the meantime, here's how you get in touch with me. If there's something that we didn't necessarily cover, or you had any questions, or if I went to something too quickly, or spoke too jargonly, then again, we are here to help you. As OVW grantees, we are here to answer your messy, complicated questions. It really is kind of what I really love doing is, VAWA and admissibility. Thank you, Catherine. VAWA and admissibility. Sorry, I have to scroll up. Maybe if you can recite. So you had this VAWA client spent a year in Mexico with his family when he was 10, and EWI, both entries, and no detention. So what you have is kind of an issue with the unlawful presence, which doesn't kick in until you're 18. But I think it depends a little bit fact specific in terms of when he came in. So why don't you just email about this? And you can email me directly about this, and so we can kind of get a sense of the timing, because it might be that you have a permanent bar issue, but not necessarily an unlawful presence one. So I think I just need to kind of dig a little bit more into the facts. Any other questions before I give you a half hour more to your day? Well, if you can think of no more burning ones, this is how you reach me. I am extremely happy to help all of you. I think it's really, it's something that I really enjoy doing, is helping you walk through the complicated, messy stuff. Some people shy away from that. I actually find it really interesting and energizing. So I'm happy to help you as you kind of go along the way. So if there's no more questions, thank you so much, everyone. Have a great rest of your day. Okay, FOIA. Tatiana, how much risk on doing FOIA? I haven't heard of any. I know that people are kind of concerned about whether or not they're FOIAing ICE or they're FOIAing other kind of agencies, whether or not that kind of puts any risk to client. It depends on where the FOIA is going, but I have not heard of any kind of, risk just because of the filing of the FOIA. But I think, again, please email me with the specifics so we can kind of walk through it more. Thanks, everyone. Have a great rest of your day.